and Ray Jesse James from.
Yes, counsel. Good morning.
Good morning, Honorable Chief Justices of the Court. If it please the Court, my name is Jesse D. Schomer. I am the petitioner pro se in this matter. I'll provide a brief recitation of the factual background of this case. This case involves an application for admission by motion to the Bar of the Commonwealth of Massachusetts, which was filed by myself in September of 2011. Essentially, the facts of this matter are uncontested by the Board of Bar Examiners. I'm a graduate of the University of Notre Dame Law School, class of 2004. I'm admitted to practice in the state of New Jersey since 2004 and in the state of New York since 2009. I've been engaged in the active practice of law since 2005, with the exception of 2 brief 3-month periods of unemployment in 2005 and in 2009. I have never failed any bar exam, and I paid all the fees and submitted all the requisite documents in connection with my application.
I guess what perplexes me here is we have the Board of Bar Examiners saying that your practice of law in New York for 5 years was illegal.
That's correct.
It would seem as if there should be clear New York guidance as to whether a New Jersey attorney may do what you did. But I haven't found it, at least in the papers presented. Do we have any guidance from New York as to whether or not it is okay to do what you have been doing?
There's very little law on the question before the court here, which is the board has helpfully clarified is their sole issue of contention, was whether my years of practice while I was licensed in New Jersey in practicing in New York as a temporary contract attorney, whether that was legal.
But go ahead.
The only statutes in place that are cited by the board are the very general statutes as to the engaging in unauthorized practice of law. There's
I think
no
Justice Gantz is asking about New York authority.
Right. So there's no authority suggesting in the state of New York, in the state of New Jersey, or in the state of Massachusetts that I found suggesting that the temporary practice of law in one state while licensed in another is the unauthorized practice of law.
But let me ask you that on that exact point. The ABA model rule that I guess Massachusetts has adopted, and New York is thinking about it, and New Jersey has a version of it.
Correct.
But the ABA model rule talks about temporarily, and I guess the issue becomes is 4 years, or I'm trying to get my math right, from 2004 to when you were admitted to the New York bar, and you were practicing in New York, I believe, the whole time. Is that right?
That's correct. There were several periods of employment that were separate temporary periods.
Right.
So the lion's share of it was the end of 2005 through the end of 2008, approximately 3 years.
So it's calling that temporary that I'm having some difficulty
Understood,
with.
Your Honor. My argument would be that the correct understanding of the word temporary in this situation is as it's used in the practice of law. Temporary would be more or less synonymous with contract. So I was hired as a contract attorney by a placement agency. I was placed at Sullivan and Cromwell in New York City, and I had an open-ended contract, and I worked for only as long as this case proceeded. Once the case ended, I was off the case and I was no longer employed.
Suppose you'd been an associate at Sullivan and Cromwell doing exactly the same thing that you did.
It would depend on if I was holding myself out as admitted to practice in New York State, which, as I say in my papers, was never something that I did.
All right, but
you were not appearing in New York courts.
That's correct.
But you were, in the time that you spent at Sullivan and Cromwell in New York, you were working on matters of New York law, among other things, yes?
It was a federal regulatory matter, and it was a multi-jurisdictional discovery in which the Department of Justice was investigating an international bank. And
So you worked on one matter for Sullivan and Cromwell for 3 years?
it was one single matter.
And you were engaged to just do that one matter?
That's correct.
And so your employment was just as long as that matter was?
That's correct.
And I take it, if I understand the board's position, if you had sought, if that matter were in court and you had sought pro hoc vice admission in New York, the board would say that would count, correct? correct?
That would be my understanding as well.
Did you advise clients in New York?
Not directly, Your Honor. I was involved in the review of documents and making calls as to privilege or confidential status of certain documents that we reviewed. We drafted in-house memos that were submitted up to attorneys, but every single thing that we worked on was subject to the supervision of New York licensed attorneys. We never appeared in court. We never signed documents. We never held ourselves out as admitted to practice in the state of New York. And I'll just point out that the general practice in New York, as well as in this state, is that for matters such as this, the placement agencies, their actual advertisements will say, we're required to have attorneys who are licensed to practice in any state, because the matter that you're advising indirectly through the locally licensed attorneys are matters that any attorney would know how to do, such as making calls for attorney-client privilege, confidentiality, et cetera.
Can I ask you a question on the, you were admitted to the New York Bar in October of 2009.
That's correct.
Which would have been after this period of time.
That's correct.
Do we have in the record your papers in connection with your admission to the New York Bar? I mean, the point that I'm driving at is, did the New York authorities, in deciding whether or not to admit you to the bar, have before them information that you had been practicing at Sullivan and Cromwell as a contract attorney?
I'm glad you asked that, and that's something that I raised in my reply brief, which I recently submitted to the court. That information, it was not included in the record appendix, but that information was provided to the New York Bar, and it was considered by them, and I was admitted. And I'll also point out that that same information was also submitted to the Federal District Court, the District of New Jersey, Southern District of New York, and Eastern District of New York, all of which admitted me to practice in those courts.
And did they have a, you made a reference at some point to the New York Bar Association applying Model Rule 5.5 in making ethical determinations, but I didn't see your citations to any of them.
The citation that I provided, I believe, were more or less, they're not controlling authority, they're not a model rule per se. The primary source that I cite is a report by the New York County Lawyers Association, the New York State Bar Association, and the New York City Bar, which was recently submitted to the New York Court of Appeals, recommending that Model Rule 5.5 be adopted in full. And they provide extensive guidance and recommendations, which I argue in my papers indicates how the bar associations apply the ethical rules, whether or not codified as a version of Model Rule 5.5, to suggest that the practice that I was participating in was legal and was ethical. And I also point out in my papers, Your Honor, that I sought informal opinions from each of these bar associations. I provided them the relevant details of the practice, and the informal opinion from each of them was that this was both lawful and ethical practice.
Now, you're not seeking to be admitted on motion. You want to take the bar exam.
No.
Seeking to be admitted on motion.
On motion. And when you were admitted in New York, were you admitted on motion, or did you take the bar exam?
Bar exam, Your Honor.
So when you made the disclosure to the New York equivalent of the Board of Bar Examiners, you made the disclosure about the nature of the work that you were doing in New York.
Correct.
But it wasn't offered in support of a motion to be admitted, and it was not offered in support of a motion to be admitted.
That's correct, Your Honor. That's a fair point.
Is what you were doing in New York not the practice of law?
I'm sorry, can you repeat?
Is the work that you were doing in New York, which did not include any advice to clients, which did not involve appearing in court, is what was left, everything is what you in fact did it amount to the practice of law?
It did, Your Honor. That point is also conceded by the Board of Bar Examiners. While I was not providing direct advice to clients, the advice that I was rendering was put up the chain through the supervising attorneys, and it was ultimately sent on to the clients based on whether they approved of the advice that I was rendering.
And you were billing as an attorney?
I was billing hourly as an attorney, Your Honor, yes.
And you were not on the letterhead?
No, Your Honor. I was not on the letterhead.
And that includes also not on the letterhead of the firm that you're now part of? I don't mean since you've been a member, but you worked there, right? Or did you not work there before you were admitted?
I did. I was working there pending my admission to practice, and I was not on the letterhead of my current firm. That's correct, Your Honor.
So when you were working during this period of time in New York, were you paid by the placement agency?
That's
or-
correct.
I thought
The
that's- I thought-
Sullivan and Cromwell would
Right,
pay,
contract of
or
placement.
would bill their client. The client would pay Sullivan and Cromwell, and then it went down to the placement agency who took their cut, and then the rest went to me.
Is the, this keeps happening to me. It has to do with the placement agency. Never mind, move on. I'm
Okay,
sorry.
well, she's thinking. The informal opinion you made reference to, is that with regard to you or with regard to other people?
It was with regard to me specifically,
So you have a written informal opinion?
not a written opinion. Each of the bar associations provides an ethics hotline where you can call their one of their ethics specialists. You provide them the relevant facts, and it's not a binding opinion, obviously, but they can issue an opinion.
So it's oral.
It's an oral opinion based on the facts that you provide them, and I did provide them the relevant facts to this case, and the opinion of each of them was that it was lawful and ethical.
Is there any means to get a formal opinion?
There
in
is.
New
It's a
York?
lengthy process, and my suggestion would be that if the court is inclined to actually entertain this illegality argument, which I would respectfully submit is entirely without merit, this is an issue that I would request and suggest could be submitted for amicus briefs by these bar associations, by law firms, because this is a very easy argument for the Board of Bar Examiners to make with respect to one applicant who's doing this admission process pro se and attempting to contest the board's improper decision. If the board were in front of the chairman of Sullivan and Cromwell or the City Bar Association saying this practice, which is widespread in probably every state, from every large firm and every placement agency and hundreds of thousands of contract attorneys, tell all them that you are engaged in the improper practice of law. They're not going to do that, and they haven't done that. They have not, for example, they have not fulfilled their duty to report this supposedly unlawful activity as they're required to do under the ethical rules of this state.
But let me ask you, you agree, don't you, that the illegal or unauthorized practice of law shouldn't count?
Absolutely. Absolutely. I agree 100%.
Okay.
That's not to say that this was the unauthorized
No, I
practice
understand
of
that,
law.
but I just wanted to make sure that you weren't contesting that principle.
In no
Okay.
way.
And do you agree that you were in the period of time, I suppose still, but certainly in the period of time, that 3-year period of time that seems to be the focal point, that you were bound by the rules of New York as well as New Jersey?
That's an interesting question, and that's one of the questions that the report to the Court of Appeals was addressing, was that in theory, for myself, for the practice, I was only subject to the ethical rules of the state of New Jersey. The recommendation of the Bar Association is that the rules of ethics be applied to those attorneys in the state of New York. And it's stated for various reasons, such as that you would better regulate this multi-jurisdictional practice of law in the state of New York, which would provide great economic benefits to clients, to law firms.
So are they are asking the Court of Appeals to adopt a rule saying this is okay, but you should adopt a rule saying that individuals such as yourself are subject to our
Correct.
disciplinary rules.
That's correct, Your Honor.
But New Jersey does have that model rule. Doesn't it adopt 8.5, which
5.5.
I know 5.5, but 8.5, isn't that the one that talks about multi-jurisdictional practice requiring that you would be subject to the both states?
I believe that's right, and my understanding is that New Jersey has more or less adopted the model rules in total.
Okay, so because you're a member of the New Jersey Bar, that would subject you through the New Jersey rules.
Correct.
To being bound by the New York rules as well.
That'd be correct.
Now, going back to Justice Spina's question, when you passed the New York bar, am I correct that you had to be interviewed for character and fitness?
Correct, Your Honor.
So you had a character and fitness interview,
This is correct.
and that person would have had your resume before him or her.
He did.
And was there any question raised with regard to your practice during the course of that interview?
Not as regards the unauthorized practice of law.
And I take it you would suggest that that's because this is a common practice.
That's correct, Your Honor.
Nobody was surprised.
No one was surprised in the least, and that's, it's hard to argue against the position of the board here because there is so little authority on it. But this is a very widespread practice, and there was no issue with it in any of the bar applications that I made. It was, please.
No, finish the statement. I didn't.
I was finished.
In terms of the kind of rules that you lived by, didn't appear in court, didn't sign anything, always going up through the chain to a licensed New York attorney. Are those formal in any way? Are those written down anywhere? Where did they come from? I mean, I'm not saying they don't make sense. I just don't know. Do they have a situs?
I suppose they're formalized in terms of the firms don't want to engage in the authorized practice of law, and so
they consider those things to be indicia of unauthorized practice.
right. That's pretty well stated in New York case law that, such as signing documents, appearing in court, those are the indicia of practice of law in terms of whether you're holding yourself out to be admitted.
So could you have done this work in New York if you had not been admitted in New Jersey?
If I had not been admitted in New Jersey, I could not have
Some
done the
bright
work.
high school kid
No,
comes in
absolutely not.
and works goes to one of these contract agencies and he's a member of Mensa and all that kind of stuff, and signs up to do this kind of research and does it.
Could he do the work? Possibly. Would he be authorized to do the work? Would it be the unauthorized practice of law? It would be the unauthorized practice of law.
And how do we know that?
Well, because you are making decisions as an attorney. You're making advice decisions. You're making calls that you went to law school and you became admitted as an attorney to be in a position to do that sort of thing.
And as a practical matter, if I understood what you said earlier, the contract agency isn't going to hire you unless you're admitted to a bar.
That's correct.
Thank you, counsel.
Thank you, Your Honors.
Good morning, Your Honors. Jeffrey Bach on behalf of the Board of Bar Examiners. May it please the court. Just a few initial things. I have not even seen the reply brief, so I don't know what's in it. So if I have any questions on that, with all due respect, I have no idea what's in that brief. We actually exchanged briefs by email, but apparently I didn't get that one. Let me just respond briefly to my
Could I just say this? I think if you feel that there's something there you need to respond to, you're free to write a.
Thank you, Your Honor. But I think that what's happened just briefly in my brother's oral arguments, I think has narrowed the issue quite interestingly, and I think in a way that I think makes the court's decision, with all due respect, somewhat simpler. I think I heard my brother say that he does not disagree that the unauthorized or that the illegal practice of law does not count for purposes of our motion, which we have obviously strenuously argued, and which I think the court should so find.
That wasn't the initial basis on which the board turned you
right.
down.
And the reason
So
that
that's evolved over time.
It's not evolved, Your Honor. Our position has been consistent throughout, which is that we believe that in order to be admitted on motion, and I will add that motion admissions are approximately 5% of our admissions every year. It is a minority. It is the back door, if you will, not the front door compared to the bar exam. We believe strongly, and I add unanimously, the board believes this, and it's longstanding practice, is that a practice that counts has to be a lawful practice. Presumptively, that means that you practice in the jurisdiction in which you have been, admitted.
But that's not what the rule requires. A strict textual analysis of the rule does not lead to that result.
The rule requires that there be the so-called active practice, and the active practice phrase is not defined. We regard active practice as being a lawful active
Oh, I understand
practice.
that, but it says, shall have engaged in the active practice or teaching of law in a state. It doesn't say that it has to be the state in which the applicant was admitted.
Absolutely correct, Your Honor. That's because there are so many exceptions that come in. For example, in-house counsel. For example, government attorneys, pro hoc vices. We detail all those.
Where is all that? Is that now written down, the exceptions?
Well, all those exceptions are, of course, contained within various rules and precedents. We have, in fact, issued an advisory in this area, and obviously...
When did you do that?
We did that actually after this case arose because this issue kept on coming up. And I just want to raise something briefly. My brother's argument primarily is that this is so, widespread that it becomes acceptable. And I just want to cite one thing. And on page 14 of my brief, we cite extensively the New York statute. It's 47076A, which says in relevant part, quote, "It shall be unlawful for any natural person to render legal services," unquote, "unless they are a member of the New York bar." I regard that rule as unambiguous.
So do you mean to say that in New York, there's a Boston branch and a New York branch, that if there's a big case in New York and they bring in 7 associates from Boston to work on that case in New York, they are engaging in the illegal practice of law and therefore should be disbarred in Massachusetts for engaging in that?
Of course not, Your Honor, because of the fact that there are, exceptions, and that brings us to the one that we have here, which is the so-called temporary or in the case of New Jersey, occasional exception. That means, that I can go down to New York and, help out on a case, conduct an arbitration, negotiate a deal, so on and so forth. But that cannot mean year after year after year of practicing in the same law firm on the same matter not being admitted. That is a continuous practice under the rule, or a, quote, regular practice, and that's different.
It's not that uncommon for there to be 3-year cases that are quite large, especially in New York.
And then, with all due respect, if it then stops becoming temporary, just because of the fact it is, widespread, doesn't make.
Well, you say temporary, but that's not. But that's not the language of the New York rule. Does not speak of.
Well, the temporary
There'd be an exception
is
for
the ethical
temporary.
rule, Your Honor. Actually, the criminal statute is unambiguous on its face, where it says if you do the temporary practice.
So under the unambiguous language of the criminal statute of New York, you're saying that what I described, with the Boston firm sending their associates to New York, would be a crime in New York.
I suppose so, Your Honor. However, I would say that the ethical codes are important gloss on top of that, and that is what the courts have applied and allowed. And in that case, it is the temporary practice which is allowed.
But, Mr. Vogt, would you say, if I understood correctly, that Mr. Schomer worked on one matter at Sullivan and Cromwell as a contract attorney? So if that matter, right, if that matter were in court and he were admitted pro hoc vice in New York Federal District Court, Southern District, because it's there, and he spent the exact same amount of time, did the exact same stuff he was doing, that would be okay?
Absolutely correct, Your Honor.
What are we to make of the fact that when he applied to take the New York bar exam, he disclosed everything that he was doing in New York, and he wasn't he wasn't denied the opportunity to take the bar exam because he was doing something illegal?
The fact that the New York Character and Fitness Committee, which is actually done after you get admitted in New York and take the bar exam, after you take the bar exam, and in New York it's a little bit different than our system. The fact that they chose not to pursue this matter is a different issue. It doesn't make it the lawful practice in New York, and I respectfully point Your Honors to the D.C. advisory opinion. I realize it's D.C. and not New York, but in the D.C. advisory opinion that I attached onto my brief, they unambiguously say that if you come in as a contract attorney and it's not truly temporary, incredibly short term, you should become a member of the D.C. bar, even if you're working as a contract attorney. This court should be standing for what is, right under professionalism, and if it isn't being done right.
That's actually, frankly, what we're worried about, and that's what Justice Gantz's question went to. In this world of high-powered law, international law, associates do get moved from Chicago to New York to work on an international arbitration that's taking place in London but being managed out of New York, and so. We want to make sure we're not calling that unethical. It certainly doesn't appear to be unethical to us. It seems to be part of the practice. They are working under the supervision of attorneys licensed in New York to the extent that they need to be. So yeah, we're worried about that too, but it's hard to understand how this case presents that universal problem.
This case presents that problem because of the fact it deals directly with the issue about what an attorney should do when they start a practice that lasts for multiple years in another state. Attorney Schomer should have applied for the New York bar, I believe. But the crucial issue here is that he can still become a member of our bar. He's a-
When
you say
when
that,
you deal with a
you-
character and fitness, are you going to say, well, you practiced law for 4 years illegally, we can't possibly admit you?
The character and fitness issue is an interesting one. We had not yet, reached it. That's an issue under the Prager standard, as this court knows. It's a fairly hard standard to fail under this court's, precedents. That isn't an issue of that we have reached. It is an issue of that we perhaps will have to reach. And certainly, if you rule them in favor of the applicant, this has to be, remanded because, for example, I'm accepting all these representations as to his practice on face, value. We have done no background check on him. So I assume them, but there obviously are issues. There's also a bankruptcy, and there's some other issues in his background that we have to check on independent of these issues. But I just want to...
Mr. Bach, I'm hearing you say that it's acceptable if a lawyer chooses to be a contract attorney for a reasonable period of time, but if they do it year after year, that's not acceptable. Where's the cutoff point? How long is reasonable?
Well, that gets you into actually the real line is between temporary and continuous.
Well, so where's the line?
I would argue, Your Honor, 6 months or a year, perhaps. I don't know where that line is, and I've looked and I found no, precedent for it. But the ethical rule that certainly my brother cites to makes that line, and which says that it is wrongful that the practice in Massachusetts, for example, and every other state has the same, rule, unless you fall under one of these exceptions if you're not a member of the bar. And the exception is the temporary practice of law. I fully accept the temporary practice of law. So that interestingly enough, if, Mr. Schomer had, practiced for 3 months in New York and the rest of the time in New Jersey, we would not be here.
Well, but suppose he had worked for a temporary agency, a temporary contract lawyer agency, and he got 12 3-month assignments at different law firms, all of them in New York City.
That exact issue, at least in the D.C. context, is, raised in the D.C. unauthorized
But
practice
New
law.
York hasn't said anything about this, and you're saying that it was the illegal practice of law in New York. So we have to determine for New York what the illegal practice of law in New York is?
I think that this is why the board believes that we need a simple, bright line which says that if you don't fall under any of these clearly lawful things, then it does not count as the active practice, and thus
Having read the advisory that was issued, I'm really completely puzzled about how it is that it's different for in-house counsel. I mean, let's just suppose a lawyer works for a big oil company headquartered in New Jersey where that lawyer is licensed, but he's assigned to work in the New York City office of the company, and the task that he's assigned winds up taking, I don't know, a year and a half, 2 years. Is that okay?
If they fulfill all the requirements in New York, which, for example, Massachusetts requires that the in-house counsel actually register with, with the BBO and go through whatever requirements they have. I do not know what the New York one is.
But the question is, under the way that the advisory is construing the rules, would this be considered the unauthorized practice of law in New York? If he had been in-house counsel for a New Jersey oil company that sent him to New York to work as in-house counsel?
Assuming that New York has the same in-house counsel rule of the law that we have, no, it would not be.
I don't understand why that is okay under some notion of the temporary practice of law.
Because there is a specific exception with, in-house counsel.
Well, who's made the exception?
Actually, your court issued it in the question of the rules with respect to in-house counsel in, Massachusetts. There are specific rules about in-house counsel.
You've made that rule.
Absolutely, Your Honor.
New York have that rule?
Honestly, I don't know, Your Honor. It is part of the basic ABA system, and it's designed to allow in-house counsel to move around and yet still be, regulated. I know in Massachusetts, that lawyer has to register with, the BBO, and thus, has to, clearly come underneath our disciplinary system and our regulatory system. Attorney Schomer falls sort of below below the cracks. And keep in mind, though, that our regulatory system is, the BBO, it is, IOLTA, it is the character and fitness screening of the BBE in our case. There are important reasons to make, people become members of the bar.
Isn't he still subject to the New Jersey rules? I mean, he's
He would
subject
still
to
be under the New
rules.
Jersey rules. Sometimes, obviously, the rules differ, and that becomes an issue. But yes, he would still be under other New Jersey rules. However, for example, let's assume that a client complained about him, and they called up the New York equivalent of, bar counsel. They would not have Attorney Schomer on their rolls. They would not know where to, address it.
Do you know that?
One of the reasons, though, that we keep this system is because of the fact we check with the equivalent of, the bar counsel in all the various states so that a person is, admitted with respect to Attorney Schomer, but for the fact that he's since been, admitted in New York, we would not know if a client had, complained about him, because the client couldn't know to go to, New Jersey, because he's dealing with Sullivan, Cromwell, in New York.
But he actually doesn't have clients, so there would probably not arise.
But the rule is the same. I mean, we sent you a copy of a Supreme Court of Utah case. In paragraph 17 of that, it makes on the point that we need uniform rules so that we can apply at the BBE, so that there does not appear to be any partiality or any favoritism. We applied the same rules for large firms in Boston as small firms out in Pittsfield. We feel strongly about that, so that we have to have a uniform set of rules that allow for us to apply them.
But you're saying it was the unauthorized practice of law in New York. I don't understand how these arguments fit together.
Perhaps I should be clear. We believe that New York law presumptively says it's illegal based on the statute I said to you. There are certain exceptions that fall in place. The one that my brother relies upon and that we admit is there is the temporary practice of law, although technically New York hasn't adopted it. New York de facto has sort of adopted it, and we accept that. But the fact is that we say multiple years of the same practice is not the temporary practice of law.
But that's not something New York has said.
That except by saying that this is our law and not having anything to the opposite. In
And
other
then
words,
having admitted him to the practice of law after, this was disclosed.
that's correct. They admit thousands of people. They do interview them. I don't know.
So I guess what I'm saying is, how is it that we are going to say to New York, basically, we will construe your law in a way that you have not seen fit to do?
What I'm asking this court to do, and what the board is asking, what the board is asking is to take the highest road here and to say that you need to show as an applicant that your practice was lawful. We do not believe that this practice was lawful. Even if it is widespread, it is not lawful, and it's something that we should be...
This is very complicated. You say this should apply uniformly. So you have someone, a senior lawyer at some firm, large firm, who's applying on motion. Is it your position that you should get from that in-person information about every place in which he has practiced law for the firm to confirm that if he was practicing in L.A. on a major case, that was legal, and in maybe New Orleans on another case, whether that was legal? I mean...
No, what we look at is the last 7 years, and we look at whether or not in those 7 years you have 5 years in which you are regularly based in a place in which it was.
So it's regularly based. It has nothing to do with where, in fact, your practice is.
You might have a nation.
Your office is in
nationwide
Chicago, but you actually spend a lot of time in New Orleans or
That's correct,
New
Your
York.
Honor. That's correct. And we're trying to find a rule that can be applied in a fairly uniform system. As I said in paragraph 17 of the Spencer case, so they discuss the importance for that. That if we get into a individually looking at every single applicant and every single thing and poring over it week by week by week and case by case by case, we'll get set up in a system in which there will be at least the appearance of favoritism. I will add, Your Honor, as Your Honor I'm sure knows, there is a safety net below all this, which is that in extraordinary cases this court has allowed in on waiver, and of course so there's also the huge safety net, which is that Attorney Schomer can of course take our bar exam.
But I worry about that for precisely the reason Justice Gantz said. If we were to conclude that you're right, that he's been engaged in illegal practice of law in New York, how could he pass the fitness test that we would assume that the BBE would be applying when he passed the bar exam here.
We haven't yet
but
reached
this
that
is
issue.
complicated.
We haven't yet reached that issue, Your Honor. But I assume that, I certainly ask it that if this matter is, remanded, that it has to go through a character and fitness review as much on, other issues. I mean, I don't know of other lawsuits. I don't know other things. And I'm not, impugning him. I'm just saying applicants have certain issues and that they're important. And we take this very, very seriously because the fact that this is all about, making sure that people do not come in here who we think are going to be improper members of our bar.
Is there no process by which the Massachusetts BBE can ask its counterpart in New York whether or not what he did is illegal in New York?
No, we have approached our counterpart in New York, and they have informed us informally that they take the same position we do on motion applicants, which is that it requires it to be a lawful practice, meaning that it fits in within.
Well, of course, of course, it has to be the lawful practice. That's not the question. The question
but
is,
their definition is the same thing as ours. So with all due respect.
So you're saying that they have said that what Mr. Schomer did was illegal under New York law?
What they're saying is that if they had the mirror image and they had somebody sitting up in Massachusetts on a New Jersey license doing it, they would have serious reservations and probably would not admit the person into New York on motion. In other words,
But the question is really, if this is not illegal in New York, is there any problem as far as you're concerned? If New York were to say what he did is not illegal under New York law, would there be any objection that you would have?
I think I can answer this question incredibly simply. If there were a rule which says that if you act as a temporary attorney under a contract thing and you go through all the following things and that is in fact lawful, we could admit him. Absolutely correct.
Do any of the
We
states?
accept lawfulness based on a state-by-state determination as best as we can, figure out what is lawful in the state.
Do any of the states require somebody who is in the state practicing temporarily to notify the local equivalent of the Board of Bar Examiners or Board of Bar Overseers?
To my knowledge, no, because once again, temporary is designed to be you go down, you take a deposition, you do an arbitration, you advise a client. It's by definition temporary, so you don't advise.
But you're saying temporary is not 3 years.
That's correct, Your Honor.
All right, we'll have to leave it there. Thank you very much,
Thank you
sir.
so much, Your Honor. Thank you.